Yesterday, the Departments of Homeland Security and Labor published a temporary final rule, increasing the H-2B cap for fiscal year 2019 by an additional 30,000 visas. The additional H-2B visas are available only to employers which attest that they will be likely to suffer irreparable harm without the ability to employ all the H-2B workers requested in their petition. In addition, these visas are available only for returning workers who received an H-2B visa or were granted H-2B status in one of the last 3 fiscal years. As in previous years, this increase is based on a time-limited statutory authority and does not affect the H-2B program in future fiscal years. On Wednesday, May 8th, USCIS began accepting petitions for these supplemental H-2B visas and will continue accepting petitions until the supplemental cap has been reached, or September 16, 2019, whichever is sooner. Employers who are eligible for H-2B visas under the supplemental cap must submit Form I-129 along with a valid temporary labor certification and attestation form ETA 9142 BCAA-3 to USCIS. On the attestation form, the employer must affirm that its business will likely suffer irreparable harm if it cannot hire all the requested H-2B workers before the end of the fiscal year. On the same attestation form, employers must also attest that each worker it requested and/or instructed to apply for an H-2B visa is a returning worker. Same as last year, irreparable harm is defined as permanent and severe financial loss. A few things that AILA members should be aware of when assisting clients to apply for these additional H-2B visas. First, petitioners who file an I-129 petition 45 or more days after the certified start date of work on the temporary labor certification must also conduct a fresh round of recruitment for U.S. workers. Secondly, petitioners must retain evidence and records demonstrating that their business is likely to suffer irreparable harm if they are unable to employ all the H-2B workers requested in their petition. Petitioners must also retain evidence that the employer requested and/or instructed that each of the H-2B workers petitioned under this rule were issued H-2B visas or otherwise granted H-2B status in one of the last 3 fiscal years. And finally, the decision on whether to run a lottery will be made by USCIS based on the number of petitions it receives. USCIS will not begin processing petitions until a determination is made concerning whether it will be required to conduct a lottery for those petitions received within the first 5 business days that filings may be accepted, and any such lottery has been completed. For more information about the temporary final rule and frequently asked questions, don't miss AILA's practice alert entitled Additional 30,000 H-2B Visas Made Available for the Remainder of Fiscal Year 2019. Also, a copy of the H-2B temporary final rule, the attestation form and its instructions, and USCIS's instructions on how to file an H-2B petition can all be found on the AILA website. Finally, if you are an AILA member and have not done so already, we encourage you to join AILA's H-2 interest group, where you can exchange ideas, network, and get advice with other AILA practitioners. To join, please email membership@aila.org.